have the case continuing with that appeal, with the Teachers Service Commission seeking the reversal of the 50 to 60% salary increment. Let's now listen in to that hearing.
On the 22nd of September, when we put the panel was a panel of 3 judges. But now the panel the court is constituted of 5 judges. I've seen an application here in the file. I've just seen it this morning, and I was thinking that we are thinking that before we go to start the proceedings, either the application or the appeal, whatever, it's good that you should know the reasons why the president constituted a 5-bench. Yes, he did it in the form of an order. I think I better read this for the benefit of everybody. Maybe it may save time, maybe it inform the public better, and all these sort of things. So, do you agree? I'll give you a copy of the order of the president. On 22nd of September 2015, I'm reading the order of this court, 3-judge bench. This court said, in adjourning the appeals, consequently, the 3 appeals adjourned to 29th of September 2015 for hearing. The president of the court is at liberty to consider the suitability of empaneling a 5-judge bench to hear the 3 appeals. When this order was taken to the Honorable the President of the Court, not the President of the Republic, the President of the Court, the Court of Appeal, he has now considered the matter, and by an order made yesterday, is dated 28th of September 2015. This is the order he made. I'm reading verbatim. 1, on the 22nd of September 2015, this matter was referred to me as the President of the Court of Appeal to determine the suitability of expanding the court from the traditional 3 judges bench to a 5 or even larger bench court. 2, it has been the practice and tradition of this court to constitute a bench of more than 3 judges for varying reasons and circumstances, including but not limited to the following. A, whenever there has arisen a jurisprudential issue to be settled by the court. B, if there exist 2 or more conflicting or contradicting decisions by different benches of this court on a specific point of law, and there is need to reconcile the conflicting decisions which require harmonization. C, where the matter and dispute is of fundamental public interest and attracts considerable public attention, and where the consequences of the decision of the court is likely to have far-reaching socio-economic, political, and other consequences. This practice by the court is entrenched in tradition and took root prior to the promulgation of the 2010 Constitution. The primary objective of expanding the bench is to achieve justice and enhance the purposes, values, and principles enshrined in the Constitution. 3, I have examined the record of the proceedings in this matter.
The preliminary objection against the appeal by the Teachers Service Commission would be an objection within the appeal, to be heard and determined within the appeal. further, you directed that the preliminary objection to the preliminary objection was itself an objection to be heard within the appeal. Speaking for myself, for my learned teacher and friend Rose Noroji, for my colleague friend Gatia, we were completely satisfied with your directions, and we are willing to start our appeal. Learned Counsel, Learned Senior Counsel Hamed Nasir then appeared after you had read your ruling, without having participated in the hearings in the morning, and I don't hold that against him. I believe that was his right, and he was well represented. I don't wish to be understood to be personalizing the matter at all, except to say this. Upon his arrival in the mid-morning, Learned Counsel then said they had a new application directed at your lordship. And I can put it no better than Mr. Naroji did on that day. The application kept mutating. It started off as an application to allow them an adjournment so that they could think through the question of whether they would participate, A, as counsel, whether they would participate in the proceedings at all, or B, whether their clients, the honorable members of NAF and KU, would themselves participate in the appeal at all. The application then mutated and became an application as to whether there should be 3 judges or 5 judges. You, your lordships, in your wisdom and from your experience, you directed that you had given a week for the parties to consider the issues they had placed before you. So this application this morning must not be seen in isolation. It is, in our very humble view and with tremendous respect, it is a further mutation of the original application. Now, why do I say that? This application, and my Lord, President of the Court, you put the question to my learned colleague. Now, I think it's my lady who put the question to my colleague. You asked him, did you prepare this application to complain against this 5 bench or to complain against the 3-judge bench? He said the 3-judge bench. I thought you were inviting him to make observations whether now as further expanded, he still has the same complaint. That to me remains unexplained. But now, having gone to the background, let me ask my lords, in the 2 minutes left to me, let me ask, what is the complaint? We have been told that Mr. Sosion, who rejoined